we go. Well, good afternoon, everybody, and welcome back to episode 18 of our regular association leadership series. Thank you, Nez. As a reminder, you're welcome to chat in your questions through the Q&A feature, and I will try to work some of those into the discussion. If we have some time at the end, we'll address specific questions. I want to welcome back Jeff and Michael, and welcome our special guest today, Henry Robbins, who's the EVP of Cooperative Events. Is going to talk to us a little bit about what's going on in our industry. I want to remind everybody again that Michael and Jeff are not intending to provide legal advice for your association, just giving us their opinion on the items that we're going to talk about today. So for specific questions regarding your association, please reach out to your counsel. For questions, Michael, everyone knows you guys now, but how about a quick introduction?
Well, how long? We have about 45 minutes, right? So let me get started. Good morning, or good afternoon, everybody. Good to see everybody again. Very briefly, K. Bender Rembaum. For those who don't know, we are a law firm that does specialize in the representation of community associations. And in that regard, we assist our clients in all aspects of representation, including construction-related matters, complex litigation matters, obviously day-to-day operations, delinquencies, etc. We have 20 lawyers. 9 of us are board certified specialists in the field of condominium plan development law, including Jeff and myself. We regularly publish publications, Legal Morsels by Robert K., Jeff's Rembaum's Association Roundup, great stuff on all of that. Robert K. and Peter Mullengarter have radio shows, and I'm very active with legislation, some of which we'll talk about later today. So we're very well-rounded as a firm. We bring everything to the table. How's that?
That's pretty good. Jeff, did he miss anything?
Usually he likes to discuss how happy he is that I'm his partner, and he goes on and on and on, and I've asked him to dial that back a little bit, so appreciate that today.
It was hard.
Jeff, anything to add? Are we good?
We're good.
Good.
Mike does a great job.
Welcome, Henry. Thanks for joining us today. Can you tell us a little bit about yourself?
Sure. Henry Robbins. I'm the Executive Vice President of Cooperative Events. We're a publishing and event company. Been in business since 1976. I can't do the arithmetic that well. On your fingers. We've been doing it a while, but we do 9 trade shows in 6 states. Our focus is property managers, board members. It's where buildings meet services. The shows have CEU events. They have live vendors. They're basically it's a one-stop shop where the buyers and the sellers are sitting on the show floor. We produce the Cooperative newspaper, which is a monthly, depending on the market. We're in New York, New Jersey, New England, Chicago, Las Vegas. I'm missing something in there, but in any event, that's what we do. We've been doing it for quite a while, and we're probably we're pros running shows.
Fantastic. That's excellent. That's excellent. Henry, well, thank you, and thanks for joining us today. And everybody, before we get to the agenda, I just want to acknowledge the horrific situation in Miami regarding Champlain Tower South condominium that collapsed last week. Let's take a moment of silence before we get to the business side of this webinar, just to recognize the residents, families, and the brave rescue crews affected by this tragedy. Okay, well, I know that's in the news, and we're going to talk a little bit about some of the situation today, but polling, just to reintroduce the concept of polling, we will use the polling feature again today. Ness, let's start with our first question, just to see who we have in the audience today. And then, guys, let's just walk through the agenda. So the theme today is returning to normal. However, we will address the current law as it relates to 40-year certifications or recertifications that are top of mind for many of you. There are many questions that require answering, and there's an understandable uncertainty about how our communities can learn from the tragic events last week. We will have a special segment of our leadership series on the 7th, next Wednesday, where we've invited Tim Marshall, who's a professional engineer at AT Designs. He will join us to answer questions and address in more detail best practices as they relate to building maintenance. We will e-blast that invite out after this webinar today. Today specifically, there are several topics we want to cover: the emergency order status, changes in the law as a result of the recent end to the legislative session, a peek at what's happening in the property management industry across the country, which is why we've invited Henry, the 40-year recertification program and who that affects, and a little bit about that. And then we're going to talk about masks. So those are the 5 big buckets today that we're going to address. Now, before we do that, let's see who's in the audience today. Meredith, can you post those results? So HOAs about, wow, lots of condos today. HOA is about 38% of the group and 58% in condo. So a good group. We are having a little bit of noise on the technology side here. There's a huge storm in Plantation, but hopefully that won't affect the webinar today. So let's jump into the emergency order. The state of emergency declaration was made on March 9th, 2020. It quietly expired this weekend when it was not extended by the governor. And therefore, we are no longer under a state of emergency in Florida. As a point of interest, a month ago, we asked you if you thought the emergency declaration would end on the 26th. We're very competitive here at Castle. We celebrate wins. 78% of you said it would end. That makes you right, and that's all you need at Castle. You just need to be right. That's how we play the game over here. So
Who won the $100,000?
I did. I won the $100,000. So this will be my last webinar. No, I'm kidding, of course. In the past, we have visited the impact of the lifting of the emergency declaration on the operations of a community. So, Ness, can you post poll question number 2, please? Has your community adopted a plan to address the impact of the lapsing of the emergency declaration on the way you're conducting business? I know many communities made decisions to restrict the use of amenities and restrict access of guests and vendors to the community under the authority that was granted to them by the emergency declaration. Jeff, now that we are out of that state, are those rules still enforceable?
Craig, you're going to love the famous attorney answer of, it depends. Probably those rules are not enforceable. So let's discuss it in a little more detail. In the emergency power existing legislation, there's language, and it says that the special powers that the board had to do all those things they've been doing, such as closing of amenities and having meetings without proper notice when circumstances warranted they couldn't provide notice, are limited to that time reasonably necessary to protect the health, safety, welfare of the association and its owners, members, guests, tenants, agents, invitees, and shall be reasonably necessary to mitigate further damage and make emergency repairs. So the prior draft of the emergency legislation, I know we'll talk about the new draft later in the webinar, but the prior draft really dealt with the ability to continue using the powers after the emergency order ended when necessary to mitigate further damage and make emergency repairs. Now, the rules themselves, if you totally base the rules on the emergency powers, and there's no good reason to continue with them, I would say those rules should lapse by operation of law. If the board adopted rules still dealing with the situation with COVID, but did so based on their declaration of covenants or declaration of condominium, then it's a little different analysis. They had to have the authority to make the rule specifically as stated in the documents. The rule cannot express, it can't conflict with an express or an implied restriction that already exists in the declaration, and the rule has to be reasonable on its face. So that's like a really short primer on the validity of a rule. So if in fact it was based on the declaration, there's a 3-level test. If it was based on the emergency powers, you really better have a strong reason as to why you think that rule should still be in play.
Can you, as an association, can you restrict access to amenities in certain circumstances, in those circumstances you described then? So if you properly adopt the rule in accordance with your declaration, you can limit the?
If you had the power to limit it, if it said in the declaration that the board has power, and there are police powers, health, safety, welfare, but just to keep it closed under that knowledgeable provision that we all know that the board has let's see, they need to use their business judgment, if you will, to create a safe environment, health, safety, welfare. right? So if there's a situation on the ground that lends itself to that situation, fine. But with the emergency order out, if they don't have really specific language as to having that amenity closed, then they better have a really good reason as to why it's closed. Maybe they're doing roof work. Maybe it's unsafe to be in there. But absent that, really, we should be getting back to business as usual.
Excellent. Thank you. Okay, Michael, for you, I know that the emergency declaration allowed some other procedures to be in place. Can you comment on a couple of those, if you don't mind?
Sure. And the only thing I would add to what Jeff said is obviously boards, you should be communicating with your legal counsel with regard to these types of rules. If you're looking to amend rules or add rules, and make sure that you get written guidance, something you can stand upon that supports your business judgment if you're going to be keeping amenities closed for one reason or another, for example. And Jeff did touch upon a couple of these, but the emergency power is being lifted. We want to remind everybody, you should be properly noticing your meetings. Your board meetings, whether they be 48-hour or 14-day, depending on what we're talking about. In the condo world, in the HOA world, obviously you do defer to your bylaws sometimes for membership meetings and get clarity from, your management team is certainly knowledgeable, but it isn't, I impress upon you not to rely upon your management team to provide you legal guidance. And interpreting the time requirements for meeting notices is a legal matter. It's a one-time, you only need it once, but it is something that the managers can tell you this is what we think, but you should get confirmation from your attorney. And so meeting notices, you should be posting. There's in a true emergency, you can still address meetings with shorter timeframes, but that true emergency isn't going to be the emergency powers. It's just what the statute says. So meeting notices, borrowing funds. There was some question as to whether borrowing funds could be undertaken without a vote of the membership if your documents required a vote of the membership. I'd say that's the second item I would mention, Craig, is that if your Chapter 617, which is your Not-for-Profit Corporation Act, essentially says that unless your articles or bylaws provide otherwise, the boards can borrow money and pledge collateral. So you have to look to the governing documents of the association. Under the emergency powers, there was some indication that maybe you still had the authority to borrow, even if your documents required a membership vote. Well, that's gone. So do know that if you're looking, and I've had a lot of loans coming up lately, if you're looking to borrow funds, you absolutely should be getting in touch with counsel. I just did a whole class on that. I'm doing a class with Castle actually in August on that, about funding construction projects. You absolutely need to know if you need a membership vote to borrow, because the state of emergency is lifted. You're not going to be able to use that as a way to get around that vote.
Okay, good stuff. So hopefully those days are gone forever, and we will not look to revisit that, although I know the statutes have changed. We're going to talk about that shortly a little bit. Nesk, will you post the answers to poll question number 2? Has your community adopted a plan to address the impact of the lapsing of the state of emergency declaration? So 38% yes, 57 no. I think that's pretty impressive, actually. That speaks to our forward-looking boards who are, I guess, returning to operations, but they do have a formal plan, which I think is important. Guys, we've always talked about, do what's right and properly communicate it, all blessed by your attorney. That's kind of been our general guidance. And so congratulations to those associations that have adopted a plan. And for those that haven't, maybe something you want to look at just to make sure you're on side with respect to your attorney. Jeff, if you haven't, for 58% of the folks out there who haven't adopted a plan, do they have some time still?
To adopt an emergency plan?
No, is it done? Like the emergency order ended, are they in trouble? Or do they have a little bit of time to return to normal?
They have time to return to normal, but they should make it an absolute priority to begin returning to normal before a member gets upset that perhaps the gym is closed and wants it open and goes to see their lawyer, who then contacts the association. I also want to add to what Michael said just a moment ago, most eloquently, that if you live in a condominium and for any reason you have language in your declaration that would require a vote of the membership to borrow money, to make repairs, needed repairs, whatever it is, please reach out to your lawyers right away. There is a whole long line of cases in the state of Florida, and we can talk more about it next week on the webinar on Wednesday with Tim at noon. I call it the Tiffany Plaza progeny, But the short story is there is appellate case law in the state of Florida giving the board the power to do what it needs to do when repairs have to be made that affect the safety of the members and the safety of the property itself. So we'll talk a whole lot more about that next week. That's a teaser, but because we have so many condominium owners watching today, I don't want you to get bogged down in your documents. No, we can't do those repairs because we need a vote. I don't want to ever hear those words from anybody watching our webinars. You just need to reach out to your counsel who can walk you through the steps.
Right. This distinction that Jeff is making, though, Craig, is that if you don't need the vote to do the necessary repairs or to pass the special assessment. But if your documents say you need the vote to borrow money, that vote you still need.
Fair enough. Fair enough. Guys, I'm going to go off script for a second here because we're getting tons of questions on virtual meetings and being able to conduct meetings via Zoom, which a lot of people did under the auspices of the emergency order. So now that it's lifted, can you clarify for me, and I'll defer to either of you, can I still hold a Zoom meeting, a board meeting for Zoom by Zoom, or do I have to now invite people, or what are the guidelines for me?
Different lawyers, Craig, have different opinions on this, but if you want what I consider to be the right answers, talk to Michael or me. We are of the opinion that Chapter 617, which provides clear authority for electronic meetings and also has language that says that unless there's language that conflicts with 617, that would be either in 718, 19, or 20, then you can rely on 617. What do we know about 718? We need to have 720, 719. We need to have proper notice to our membership, however it's supposed to be accomplished, posted, maybe mailed to the owners. We know members have a reasonable opportunity to comment, up to 3 minutes typically at board and membership meetings. Can all of that be done electronically? Yes, it can. Is there anything in Chapter 7, 18, 19, or 20 that says you may not follow the procedures in 617 to have electronic meetings? No, there isn't. With that as the backdrop, you can refer to 617-0820 for those of you that like to read statutes. That was 617-0820 and 617-0721. The board can have its board meetings electronically, though you're certainly going to need the ability for members to participate and comment. The fact that Zoom doesn't allow enough members, well, then Zoom is not the platform for you. You can have interaction with up to 100 people for $16 a month, and then it goes up from there. If you want to have membership meetings via Zoom, that too is possible, but first it has to be authorized by the board of directors, who have to have guidelines and procedures as they may adopt. And again, you need to perfect the right of the membership. For example, if you're going to be doing a vote, you're going to need both a physical location for the votes to be tallied. And if you're doing it electronically, you're going to need extra cameras because those members have a right to watch those votes being counted. So I think there's a balance that can be undertaken that can perfect the right of the membership to participate and observe, as well as the meeting, the board to be able to conduct its business until either a court or legislature says, no, I believe that we should read these statutes in the manner in which they were presented and which is for use to provide the guidance that we need, not to be ignored.
Right. Okay, I think that's right, and I think that's great answer, Jeff. It's in it's covered in the statute. So the quick answer is yes, you can continue to hold meetings by Zoom, subject to some nuance that might be in your document. So get that cleared with your attorney. I will tell you, in Castle's world, we are hosting a whole bunch of hybrid meetings now, where there's a group of people in the room, they're back, and we're also adding the Zoom feature so more people can participate, which has really been one of the advantages of what things we've learned in the last 15 months, through the pandemic.
Greg, one of the things we're doing as well is when the clients are following that electronic format is to make sure there is a location at the association for those, for whatever reason, aren't comfortable or don't have the ability to use Zoom. There is a common room, there is a computer set up there with the Zoom broadcast, and everybody can participate in the meeting that way as well.
Exactly. Okay, guys, let's move on to the statutory changes. Last time we looked in on this, nothing had been formally approved by the governor, notwithstanding the fact that the legislature had adopted a number of new laws. Now we're today, and the governor signed a bunch of stuff, and there are two main bills affecting community associations, SB 56 and HB 630, now signed into law. Jeff, do any of the changes to the law incorporate some of the emergency powers that were dismissed last week?
Well, they weren't really dismissed. It's just the emergency order from the governor. The state of emergency came to an end. We still have the legislation, for example, 718-1265, dealing with the emergency powers themselves. What's happened in the 2021 legislative session is that they have amended those statutes. So first and foremost, they were designed for really hurricane impact. Now they are much, much broader. And emergency now means any occurrence or threat, whether natural, technological, or man-made, no reference to China there, or man-made, in war or in peace, which results or may result in substantial injury or harm to the population or substantial damage or loss of property. So the emergency power itself is expanded. Did you want me to go into what they took away as well?
Quickly, if there's a short version, yeah.
Yes, there is a short version of what they took away. We had the power to completely restrict the property in the past, but now, notwithstanding the power of the board to prohibit access to the property, an association may not prohibit owners, guests, tenants, agents, invitees of an owner from accessing the unit, common elements, limited common elements, etc. And there's versions of this for HOAs as well, when that access is necessary in connection with the sale, lease, or other transfer of the unit, unless you have a governmental order or determination of a public health directive from the Centers of Disease Control has issued prohibiting such access to the unit. So the boards can't just say no across the board. If you're going to say no across the board, there has to be a heightened reason why, which complies with the legislation. Otherwise, the real estate business can continue. I think the realtor lobby got a hold of this legislation right before it went to the Senate. Michael would know more about that.
Yeah, you're absolutely right. And it did say, did you have you mentioned it's subject to reasonable rules and restrictions?
Yeah.
Go right ahead.
No, okay, because I just want to make sure I'm not repeating. Yeah, so what everything that Jeff just pointed out is spot on and well concise, Jeff. You did great.
That's not bad at all. So let's see,
Yeah.
Mike, you can do this.
But the only point to remind everyone is in that situation, the statute does add that it's subject to reasonable rules or restrictions in place by the board. And what that means, if we ever get into the situation again, you're reviewing your rules with your counsel, but that would mean, in my opinion, that doesn't mean that realtors can have open houses. Or board can say, hey, we're going to allow access. However, everybody coming in needs masks, and we're going to only allow no more than 2 people at a time, and no more than 4 people. At one, they're going to have to do appointments and things. Reasonable rules in that regard are still allowed.
That's good. That's good news. Okay, Michael, take us through, if you don't mind, or briefly summarize the main changes affecting condo and homeowner associations that are now law.
Okay. Well, what I'm going to say, Craig, is I'm not going to consider these the quote main changes, because I think to each their own. I will point out a few highlights in the short period of time. As you know, this is there's a 2-hour program that we provide a legal update, which will be forthcoming. Many of our attorneys have done 45 minute to an hour programs just on this, including myself and Jeff. So just a couple of things. And you mentioned Senate Bill 56 and Senate Bill 630. Those are the 2 bills I think that do have the most impact on community associations. And 630, which I think is, for the most part, a very positive bill. It's 101 pages. And so I'm certainly not going to get into that, but I will highlight a couple of things. Number one, there's a few things within Senate Bill 630 that we at FLA, the Florida Legislative Alliance, have been pushing for a few years. We didn't get exactly the language we wanted, but we did get some improvement. One is for condominiums, the transfer fee, which I think is more appropriately called an application fee, but it is a transfer fee, which has been capped at $100 per applicant, unless it said husband, wife, or parent, dependent child, which would be considered one applicant alone, was capped at $100. And you couldn't charge more than $100 to that applicant for anything at the time of a sale or lease. That dollar amount has been increased to $150. Husband and wife has now been changed to spouse, to be more correct, politically correct, I suppose is the term. But it's $150, and every 5 years, the division through the DBPR is supposed to increase it in accordance with the Consumer Price Index. So that is progress. They did also clarify the conflict of interest provision, where they got rid of that provision that said you shall not contract with a service provider if the service provider is owned by a board member or a board member's family within the 3rd degree of consanguinity. There are very specific conflict of interest provisions in the Condominium Act that do need to be followed, but you are no longer strictly banned from doing that. Let's see. I also wanted to mention about, the in condos, the 8-year term. There was in 2018, there was legislation passed that said if you serve on your board for 8 consecutive years without interruption, that if you wanted to serve a 9th year and there was going to be an election, you would need to have 2/3 of the votes cast in your favor, as opposed to just be one of the top 5 or 3 or 7 or whatever it is. And there was debate as to whether that was a prior service applied, or was this just a prospective application? Well, effective tomorrow, everything I'm talking about takes effect tomorrow, July 1st. That is clarified that it's prospective only, not retroactive. And so we don't have to worry about this term limits until 2026. So for everybody who has questions about term limits, you can put them on the back burner for at least 5-6 more years. Talk to us in 2024, 2025. We'll see if we can't get it out of the law by then.
Right.
For condominiums as well, in the HOA world, when you have a dispute, there's something called pre-suit mediation. In my opinion, it's an alternative dispute measure that's been very successful. In the condominium and cooperative world, there has only been an arbitration option. Well, effective tomorrow, there is now the option, instead of going to arbitration, you can do a statement of pre-suit mediation, demand mediation with an owner if the associations bring the action, as opposed to having to go to arbitration. We at our firm believe that is a more efficient way to go, both from a time and cost perspective, and we'll be encouraging all of our clients to do that. You should speak with your attorneys about those options if you have any questions. That is also a highlight. Jeff already went over emergency powers, so I think that's a good one. The only other one I want to point out then in 630, and by the way, there's a lot more, is for HOAs. HOAs, there is language now in there on leasing restrictions. So after July 1st, if an HOA, homeowner association, wants to adopt leasing restrictions, which will prohibit rentals for 6 months or more, those will only apply to any owner who votes in favor of the amendment, or an owner who takes title to their parcel after the effective date of that amendment. You can, in an HOA, still adopt lease restrictions that prohibit or regulate rentals for terms of less than 6 months, or prohibit rentals 3 times in a calendar year. That is still, if you do that, even if someone doesn't vote in favor of it, it will still be impactful. So in other words, in short, long-term rentals have limitations in an HOA after July 1st. Short-term rentals will, if properly approved, will apply to everyone. There's also clarification on when there's a change of ownership in that long-term rental, if I pass on and I leave it to my child as an heir, it gets the same protection I got in the long-term rental. So it's technical, but my point is, if you're an HOA and you want to adopt lease restrictions, get with your attorney, find out exactly the do's and the don'ts. Okay. Senate Bill 56 is the only other one I'll mention. To me, this is a very bad bill, something that we pushed against. We even tried to get the governor to veto it. It was a bill that was much of self-interest by one particular person in the Senate, in my opinion. And what this means, and this is very important across the board, HOA, condo, co-op, collections. If you want to refer matters to your attorney for collections, have the attorney sent that notice of intent to lien and charge an attorney fee. That cannot happen until the association has sent a courtesy 30-day notice of late assessment. And there is a specific form that you have to substantially comply with. And an affidavit of mailing confirming that you have sent it out, which I can only speak for our firm, which will require you wrote forward to us along with your backup, your ledger, etc. So starting now, all associations, Craig, Castle and all management companies need to know this, all self-managed boards, you need to communicate with your attorneys who are handling your delinquencies, and you need to find out exactly clarify this process. Our firm put out at no less than 2 emails, or 2 or 3, general to the public as well as to our clients specifically, reminding them of this requirement. And it's very, very important that this be done, because if you try to pursue a collection action without this procedure being properly followed, you now give these individuals who, in my opinion, are basically just looking to avoid paying, another procedural opportunity to claim defect. And if this is a file that's in foreclosure and they claim this procedural defect and a judge agrees, you're in a situation where you have to start over and you've got thousands of dollars in fees and costs that the association is going to be facing. So it's on a very unfortunate, unnecessary level of procedure, because in my experience, if not every, I'd say just about every association always sent courtesy late notices anyway. But it's something that we all have to deal with. So please be aware of that. Please communicate. You can go to kbrlegal.com, look at the website where we have a legal morsel on this and get more information on it, and communicate with your attorneys as to what you need to do to make sure you can continue collections against your delinquent owners and stay cash positive.
That was
Couple
excellent.
comments. Sorry, Jeff.
No, I was going to say to Michael, that was an excellent 30-second summary of
Yeah.
some pretty major changes. That last one Michael was talking about really takes the good association members who are timely paying and puts the economic burden on them for those owners who aren't paying. It's the most asinine piece of legislation to come out of Tallahassee in years, folks, all because one of the legislators didn't pay his assessments on time and had to pay an attorney's fee. This is a self-serving piece of dreck legislation. Tell your legislators you're upset about it, because Michael's going to be working on this, I hope, next year with his team, trying to get this out of our statutes.
I appreciate you toning that down, Jeff, from your real opinion.
Want to know how I really feel? Let me know.
Well, I mean, in my humble opinion, I would say, and I say in my opinion, that would be it's tantamount to it's some form of abuse of power.
Yeah.
You can't have a situation. You shouldn't be up there saying, "Hey, I got screwed by this, and now I'm going to legislate the entire state, over legislate the entire state."
Yeah.
You know, because the first part of the bill says, "Hey, listen, the issue here was they were sending late notices by mail. They changed it and sent it to this individual by email." Again, these are the facts as I understand them. If I'm misinformed, again, this is based on facts as I understand them. The letter was mailed. Late letters were mailed, and I gather people were getting. I must have gotten a late notice in the mail. This one was emailed. They didn't see the email. The first letter they got was from an attorney with a fee. Okay, so the first part of the legislation says, if you're going to change the way you send late notices from a mail to email, then you have to first notify us and get acknowledgement that we agree. It's over the top, but I can accept that. This second part that they went into, requiring every association do this courtesy notice with a form, which requires management companies to potentially have to figure out interest. And if you screw that up, you know what's happening, and the firm pursues it. Are we now exposed as a firm? Is the associate, are people now being exposed to Fair Debt Practices Act or Florida Consumer Practices Act issues? This is impacting everybody way over the top.
Okay.
Sorry.
So
Sorry,
that's,
guys. Stepping off the soapbox.
I hope you both feel better. I do. Couple of comments with respect to, and it's SB 56 that deals with collections. From a management standpoint, and most property management companies will do this on your behalf, we're adopting our second letter. We're going to continue to send courtesy reminders like most associations have adopted. The second letter will be the notice of intent, or whatever the language is, and will comply with the form that's in the statute. So it is a one more step in the process, which is unfortunate, and I certainly echo your comments with respect to one more thing for someone who doesn't want to pay to stand behind. But management companies are adopting what they can deliver to their clients for late letters. So SB 56 is what deals with this, and if you're managed, your management company should be addressing this for you.
And Craig, if I can say, and I really, this is an area where I think management companies and law firms do need to work in tandem. And I would just say that if you're, like you said, Castle's adopting letters, I would ask that send that over. Let's make sure we're all on the same page.
Great point.
And if you don't have a management company and you're self-managed, then reach out to your lawyer who can help you with those letters as well.
Right. We'll prepare a form that we will accept, and this way everybody's in line, and address that interest situation, which management companies shouldn't have to be figuring out.
Guys, quickly though, I wanted to comment on the transfer fees, the $100 limit moving to $150. If your documents say it's a specific amount, $100, you cannot now use $150, right? Your documents have
Correct.
to be silent or addressed.
You are correct, Craig. That's a great point. Thank you for making it. The dollar. We have communities that are they have $50 still, and it's $50. If you have a flat number in your documents, that's what you're charging, which is why you want to amend those documents and remove the number and have it say that you can charge the transfer fee in the highest amount allowed by law, as it may be amended from time to time. Because if you have that, which many of our clients obviously who've amended with us do, they were charging the 100. Now they can automatically charge the 150 because their document flows with that provision of the statute. But if you have a flat number, that's what you're charging. So good point, Craig.
With one caveat, just to ping off what Michael just said so well, is that your document may say you can only charge up to $50 or $100, but if you have blanket Kaufman language in the beginning of your declaration, you may be able to charge that higher number now. So even if you just see that you have that set number in your declaration without ability to change it, please check with your lawyer to see if there's any creative mechanism that might lend itself to help you.
Okay.
point.
Okay, guys, let's move on. Henry, poor Henry, 40 minutes you're sitting here. I've never seen you sit this still, although I see you getting edgy over there. So we're going to bring you into the dialogue right now. You know, we know that many communities use trade shows and like events to find vendors and for educational purposes. Do I have this right? Is that why people participate, or what are some of the other reasons?
Well, the three main reasons based on our research is the network, to learn, and to source. You know, because you think about it, where else can they meet some of these vendors? Sometimes it's just a name, you know, Joe Smith Plumbing, and then they can meet Joe himself. And then, you know, if they're not happy with an existing relationship, they can go and find people at the show that they might be happier with. So, you know, those are the three main reasons. As I'd like to just say one thing, and our research has shown, as much as these guys might grimace, they're not there trick-or-treating and double bagging.
There is some of that, but it's not a general.
You know, it's not the primary purpose. We've done an extensive research on it.
That's excellent. Well, listen, I know that, you know, they were to show up and network. Now you did kind of transfer over during the pandemic to virtual events. How did that go, and what was that experience like, and how was participation relative to what you kind of see at events?
Well, what we started out with was virtual. We had town hall webinars, similar to what you're doing, where we had sponsors who would different topics, and those topics evolved because everything was a moving target. You know, it's like at first it was the amenity openings, and then it was the change in the law, and those went very well, actually. We had anywhere from 200 to 400 participants, and it was, you know, live. Everything was live, and there was Q&A, and I think the boards really appreciated it because, look, everybody was stuck at home, right? So that was the beginning, and then about 3 months ago, we went to virtual trade shows. We had a platform. We did 4 virtual trade shows, and our experience is that it was, you know, the booth experience was not great. You know, people, you know, unlike a real show where you walk around, it's different. But the webinars, because we had webinars as well, and those went very well. People were well attended. They were very germane topics, and you know that our focus is to give people good information. You know, just like Michael and you know, Jeff here. That's the bottom line. Is there's a big thirst for information about the different things that are going on. The legislation's one, you know, and then again the moving target. Think about it for a second. You know, the CDC. Now you can actually go without a mask. 2 months ago, you would have said, it would never happen, right? I mean, now it's like, I'm in the state of New York, and we're 70% at least one shot. New Jersey's wide open. So the Javits, all these venues are opening up, which is great for us because we've been in an abyss for the last year. And we're going to be rolling. We've got 6 shows coming up in from September to December. Obviously, one in Florida, which you guys all know where about. And we're in the brand new Broward Convention Center. They take it down, they put it up. And, you know, we're excited about that because, you know, boat show's going in first.
Mm-hmm. Are you concerned, Henry, that people won't come back? Do you have pre-registrations for them? What does the attendance look like?
Well, we don't really get started with registration till 6 weeks before the show. I mean, our feedback, I mean, the vendors are all coming. Everybody's, you know, live is so different. The experience of being able to, you know, press flash and actually, you know, like I say, expositions is a full contact sport. You know what I mean? You got to throw a couple elbows. You got to grab a couple goodies, you know?
New York. Are you from New York? Is that what I heard?
No. I told you, Craig, I'm from the South. You know that, right? The South Bronx. No, I'm a Southern boy, but the bottom line is that it's a different experience. It's live, it's face to face, you know. I mean, as much as I like seeing these two guys, you know, it's nothing better than having a burger with Michael.
Yeah. Good. Well, I know we're excited for the comeback. We do business like that. Look people in the eyes and shake their hands, and we haven't been able to do that for a long time. And that's how a lot of business gets done. Do you notice any differences between the regions you're in? Like what's going on in Vegas versus South Florida?
Everything it's been a evolving status, and we scheduled all our events because we didn't want to do anything. I mean, we kept moving them, and we originally were going to be in South Miami in April, and I don't know if that would have been a good place to be for us because we like to be centrally located. We got to move it into the Broward Convention Center. I see things being wide open. I mean, people are getting much more comfortable. I mean, most of the buildings I'm in, there's no mask rule. I mean, I'm in a co-op and they dropped the mask rule. So, and the gyms are open, but obviously there's a caution. Everybody's cautious. I knew some shows that were happening in the first quarter of the year and, he made you sign an indemnity clause. I mean, why would you want to go to a show if you had to sign an indemnity clause? I mean, that's like a neon sign going, well, it's flashing. It's like, why would I want to be anywhere where I got to sign I'd have to consult these two guys and I couldn't afford it.
Well, listen, Henry, thanks for your insight. We will look forward to seeing you in Florida coming up soon. So hopefully you can stay on. And but we do appreciate your insights into kind of what's going on in our industry relative to trade shows and other shows. So thank you.
Mike, if I can just add, I have been since I went to a show last October, which was really just to see what was going on. But this year I did do in person myself in January, February, and April. And I do see that there's to Henry's point. People were very excited to be out. Everybody at that time, everybody was still masked. And there was still social distancing. The booths are a certain distance, so you can have your table here. You're 6 feet apart. But it was great. And I was teaching with my giant face mask and helmet, 20 feet away from everybody. And so hopefully people will start coming out. It is nice to see people in person.
Yep. One last thing, Craig, if you don't mind, I just want to I promised I wouldn't make this an infomercial. FL-expo.com. Hope to see everybody at the show. And again, thanks for having me on, Craig. Guys. Take care.
Henry, you could afford us, Henry. You would be able to afford us. I just want to let you know we're very reasonable with our
Yeah, you were confusing. There's the other firms you probably couldn't afford, but us
can afford us.
We're affordable.
I haven't seen your schedule lately with the update.
We haven't changed in years.
Good stuff, guys. Okay, a couple quick questions came in while Henry was speaking. Henry, thank you.
Thank you, guys. Bye.
56 applies to both HOAs and condos, correct?
What was the question?
SB 56 applies to both condos and HOAs?
It does.
And similarly, the transfer fee rules are both condo and HOA?
HOA does not have any statutory transfer fee language. You would look to the governing documents of the HOA.
Okay, perfect. Okay, because I want to jump into the 40-year recertification kind of process. There's lots of talk about it in the news these days. We're hearing a lot about it because of what's going on down in Miami and Champlain Towers. So Jeff, can you give us a little bit of background? Where does the requirement to complete a 40-year cert come from?
Sure.
Is it the statute? Who does it apply to? And maybe a little bit about the process. And I know
absolutely.
When we get going, I will say we're not going to dive too deep here because we are going to talk about this next week when we have the engineer on who can give us some more insights. But Jeff, if you could kind of lay the background for us.
Sure will. Surprisingly, despite what you might hear on the national news, Florida does not have a 40-year certification requirement. Only Miami-Dade County and Broward County affirmatively have it. I've heard rumor of 2 other counties possibly in the state that may have some type of requirement, but it's certainly not in our ordinances. In our state statutes. I think we will see it as a result of this. I think we will see some type of legislation next year, as soon as that, dealing with the 40-year certification process. And it's really a simple process. And it's one that really deals with safety more than anything else. All buildings except single-family residences, duplex, and minor structures, and they have definitions for those, must be recertified in the manner described below, where the buildings have been in existence for 40 years or longer, as determined by the building official, who he then notices the building, you need to be recertified. Within 90 days of the date of that letter, the association has to provide a report back to local government. To Helene, who was asking if the engineering reports are available, in fact, once you turn your engineering report into local government, it is discoverable, if you will. It is obtainable. And in fact, if you do a Google search for the Champlain Towers 2018 report, you're going to find it relatively easily on the internet. I know I did. So anyway, you do that report within 90 days. There are other requirements as well. We're not going into, like you said, a deep dive dealing when you have structural glazing components and other types of requirements that have to be done at 6-month intervals and things like that. But essentially, it's just a good, solid once-over from an engineering perspective of the building.
So Jeff, it isn't statute driven, it's government driven, right?
Local ordinance driven.
So
Correct.
I think there's some confusion that this is a condo issue. It's not a condo issue. To your comment, it's a building issue. It's not high-rise towers only that require 40-year certifications, given the definition you just kind of read out with respect to buildings and
I
structure.
wasn't prepared for the question, but I agree. It says all buildings. It doesn't say all residential buildings. This ordinance starts out with all buildings 40 years of age.
Right.
And then there are a few exceptions to it. So that's a really good point as well. And I question whether 40 years is really a reasonable amount of time. I think because of what we just saw with Champlain, I have a feeling these local ordinances may be dialed back to maybe 30 years. And I think our state legislation will be somewhere around that 30-year mark as well. But we'll see.
I'd be surprised if it's that long.
Uh,
It may end up there, but I mean, there's chatter. I mean, I've heard people saying, but they should be at minimum, there should be visual inspections, 5 years, maybe even more inspections on a 10-year basis, but,
Right.
different chatter, but I think 25 years is probably more likely.
That's what I said, but people have been ganging up on me every time I mention 25 years. So I went to 30.
Well, I'm not saying, I'm not educated enough on that screen. I think that's where our engineers should be coming in and giving us their valued opinions in that regard. I'm just reporting what I keep hearing.
And if you do some internet searches, you can actually go back and see the Champlain Towers from Google Pictures at different times over the past several years, where they've actually photographed the building from their cars driving around from the mapping service. And I was listening to an engineer on YouTube this morning, just from visual observation, giving his thoughts on the issues as they existed in 2018. And that was just from his visual observation of all the spalling taking place.
Yeah, because I think, though, Michael, you mentioned every 5 years, have someone look at it. There is a logical time. Boards are doing reserve studies all the time. It's a logical time to bring in an engineer to, kick the tires, so to speak. But Jeff, I don't think there's a current requirement anymore in the statute to do reserve studies, is there?
No, instead they, in Tallahassee, they put this crazy law in about 30-day collection letters that makes no sense whatsoever, when in fact, condominium associations are in desperate need of a requirement that they must have reserve studies done every 5 years to evaluate the useful components. And it's not just the sacrosanct 3 items, it's any component where the repair is going to be greater than $10,000.
I think that's a very relevant comment in that.
And Craig, concrete restoration, concrete reserve is not in the sacrosanct 3. Asphalt, pool, roof.
It's roofing, paving, painting, and any deferred maintenance over 10,000.
Right.
So I think we'll also see concrete perhaps become one of the more enumerated items in that list. Might be something worthwhile sponsoring. Hint, hint, Michael.
Well, I think the other thing, guys, is I think the requirement to do one probably makes sense. And I think we're going to see some regulation relative to these types of issues as a result of what's going on.
I hope so. So we never see another Champlain.
It was there, and then it was there at one point and then gone.
Yeah.
Mhm.
I think
it was, for some reason, I thought it was 3 years, but
I think it was
every 5.
but people do ask, and I know that we've talked about it, and I can always say it's a recommendation. And I mean, you guys are the business advisors. I'm sure you're making these recommendations also. As legal counsel, my recommendation is that you should, if you haven't had a reserve study done in the past 3 years, it makes sense that you do one. Generally speaking, they are not cost prohibitive. So, and I understand some communities, dollars can be tight. It's all relative. But if you plan for these things every 3 to 5 years and budget for these things every 3 to 5 years, it should be a fairly minor hit.
Well, you
Agreed.
know what I think, and we advocate for, if you're going to do it, don't do it because someone said to do it. Don't do it to check the box. We always say, you know, if you have an engineer, really do a study. Like, if you're really serious about this, have an engineer come and do it. Don't hire us Excel expert to, you know, make some estimates. Have someone come and look at your systems and go that route. So that's our best practice for certain. If you're gonna make the expenditure, spend a little more money and get good value. I think that's the.
And it's not about cheaping out and artificially changing the numbers in the report. You got to be careful about that as well.
Yeah, we get lost. I don't agree with what they said, so I don't want to fund on that basis. But
Right. But and again, you guys will get more into this with the engineer perspective. But it would also seem to me that you do an engineer reserve study today, and that engineering study shows things are rock solid. Well, then maybe you don't need one in 3 years. Maybe you can wait 5 or 7 or whatever it is. But if there's some things that are a little bit iffy now, then you're doing one in 3 years. I mean, dare I say it's like that colonoscopy. You know, at certain times you can wait longer.
that's fun. I go to a lot of board meetings that feel like colonoscopies, just for the record. But let's go on to the last topic today, which is mask rules. We're getting lots of questions. Marinez, I just want to quickly check in. Can you post poll question number 3? Is your community returning to normal, no longer requiring masks for vaccinated individuals in common areas? So while everybody answers that question, Michael, I'm going to ask you, can you remind us of the current CDC guidelines regarding masks?
Generally speaking, sure. The CDC's latest guidelines that I am familiar with said that if you are vaccinated, that you don't need to be wearing a mask. If you are not vaccinated, you should be wearing a mask. And in particular, certainly indoors. They also have they also have certain suggestions, like certain people, if you have certain autoimmunes or you're more at risk, you might consider wearing a mask even if vaccinated, in certain large groups, etc. But I'm simplifying greatly. It's if you're vaccinated, mask isn't necessary. If you're not vaccinated, mask should be worn.
So I think that's a great summary. And the question we're getting asked is, notwithstanding the CDC requirement of not having to wear a mask if you're vaccinated.
Not a requirement. It's a guideline. It's important to clarify that. The CDC's are guidelines. They're not, this isn't a mandate. It's a guideline.
Good point.
Recommendation. The
real question is, can associations still have rules requiring face masks in their amenities? Jeff?
I think they can right now, especially with the prevalence of COVID. It's still out there. The board members are still responsible for health, safety, welfare. Again, the powers need to come from the declaration, but there's still that overriding constitutional power, the health, safety, welfare issues that come up. And there's language usually in the decks that talk about that. There's language in the legislation. So I think that right now, given where we are with COVID, I am comfortable with my clients adopting a rule requiring the wearing of facial masks in the common area. But maybe they need to be tempered as well. What if you're all alone with your family unit? Do you still need it? But I could see it being required, perhaps maybe while walking through the restaurant, or they have a theater night and things like that, where there's groups of people in close proximity. I think it's going to be a little bit different.
I agree. I believe that, again, and we've had a lot of questions about this. Can we still require? And the answer is yes. I've got a lot more questions is, can we stop requiring it? Or can we have a rule that says you have to wear a mask along the lines of what the CDC said? You have to wear a mask if you're not vaccinated. And that's the idea. And I guess that's really where we get into the situation is you're not asking for proof of vaccinations. So if you want to adopt rules that say, hey, if you're vaccinated, you don't need to wear a mask, but if you're not, you should be wearing a mask. Essentially, you're on the honor system. And your rules should be drafted in such a way as to clarify that. And you should be communicating with your insurance agent to make sure if there's any particular language your carriers might want to further protect, if at all. But that's why those are the questions that you pose. You get with your business manager, suggest this is what we want, and then your business manager suggests, hey, let's talk with your experts. Let's get with your counsel. Let's get with your insurance team, and let's make sure we have the right language in place to best protect the association, the board, and the management.
Right. Okay, let's post the results of that survey, and it looks like about 3/4 of associations are no longer requiring masks for vaccinated individuals in common areas, which is probably what you would expect to see. I think it'll continue to trend up over the next little while, but for those of you who always want to know what your neighbors are doing, that's what your neighbors are doing. 75.
And that is my point. Is your community return no longer requiring masks for vaccinated individuals? I think a lot are doing that, but it's the honor system.
Yeah, it is the honor system for sure. By the way, is it legal to ask for proof of vaccination? Can you still do that?
Well, as far as the governor says to businesses, no.
Right.
I'd say my opinion, I think, Jeff, we agree on this, in the association, you shouldn't be asking because that has to do with medical information. And that is something that you shouldn't be asking for. And if people want to volunteer it, great. But you shouldn't be asking your residents for that information.
We
Jeff?
very much agree.
Yeah. Okay, guys, let's go to a couple of questions that are chatted in. We have a couple minutes. By the way, one question that was chatted in is, does Castle manage Champlain Towers? We've heard that several times now, that someone is out there saying Castle managed it and taking advantage of this unfortunate event to kind of draw us in, but that is not the case. We did not manage. By our understanding, the community was self-managed and has been for a long time. So just to clarify.
Really? I had heard that it was another management company.
No, I heard it was they had a project manager, but it was self-managed.
Yeah.
That's what I heard. And to your point, Craig, I don't know that people are not listening probably who did that, but do people have to be that way? Can't we just focus on it's tragic? Let's mourn, let's pray, and let's then focus on lessons we can learn from this. To Jeff's point, he's got a great article coming out on that. And going forward, how we can help in work, with the professionals, with talent, in legislature, and not start using it. That's really disappointing to hear, Craig. I'm very sorry that happened.
I appreciate that. So guys, I just got more questions. The reserve study, there is no formal requirement in the statute right now. It's the best practice, if you will. Question around 3 or 5 years. I think, Michael, you raised a great point. It really depends on what your last one said. If the last one said you're great, maybe you can wait a little longer. I would suggest that outside of 5 years, you probably want to be in the 5-year time frame at the longest. Just a best practice recommendation, no legal requirement. Excuse me. And then is there
unless in the very unlikely event your documents require it, by the way, which
that's interesting.
I don't think so, but you never know.
There is one question, regarding who would pay for an engineering report. Well, obviously it has to be in your budget, and but certainly you should require. We see most of the associations we manage have a reserve study line item. I would just suggest you really, if you're going to engage someone to do it, hire an engineer. Guys,
Craig, just real quickly, even if it's not in your budget, if you have surplus funds available and you want to have an engineering study because of what happened at Champlain Towers, doesn't necessarily have to be budgeted if there is money available for the project. The budget is supposed to come close to what you actually spend, but there's no requirement to amend the budget first before you have that expenditure.
It's a great point. This is about peace of mind for your community in a lot of cases. So, don't, and we're not talking budget breaking exercise. Last one, quick question on the collection status. If your files are already in the process of collections, what's your opinion on when this starts? July 1, I think, is what we talked about.
And I saw that, Vivian, you asked that question, and it's not a simple, quite frankly, I think that there is potential reasonable legal minds may disagree. And ultimately the party that's going to decide that would be the court if it ends up in foreclosure. I will just let you know that what we're looking at right now is, even though it's we've told our clients already, send your 30-day notice. Don't send matters over to us today because it's June 30th, right, the day before. Send the 30-day notice and we'll pick it up from there. I think files that are already in litigation, it should not apply retroactively. But it's a legal analysis that's obviously too long for this.
Probably just cover yourself. I mean, really, if you think
it depends. If you have cases that are in, like to Vivian's point, if you have cases that are in foreclosure already, is that individual now going to be able to raise, wait a minute, they didn't send a 30-day notice 8 months ago? I would sure hope not. Yeah.
Okay, guys, well, we're out of time. It went quickly as usual. Just a reminder to everybody, our next episode is July 7th, a week from today. It's a special webinar where we've invited Tim Marshall from AT Design, an engineer. He's going to come and talk to us. So the four of us will get an opportunity to maybe dive a little deeper into some of the lessons
He's a real expert when it comes to high-rise condos, and I believe he's even been at Champlain Towers in the past.
Good.
Like
Also-
a decade or two ago.
Good. Also, our president, Will Delgado, is participating in a webinar tomorrow with John Pistorino, and he's the gentleman, the engineer who actually wrote the 40-year recertification rules. So if you can look out for that invite and join Will and his gang, that'd be great, guys. Always a pleasure. Thank you very
Thanks,
much.
Greg.
We'll see you next Wednesday. Everybody, thanks for listening in and have a great day.
Thank you,
Thank
Craig.
you.
Thank you,
Be
Kath.
well, everybody.